On May 29, 2026, the Court of Appeal sitting in Port Harcourt delivered a judgment. That judgment upheld an earlier ruling that nullified the congresses that produced Tony Okocha as the APC chairman in Rivers State. Okocha is Wike's man. He has been the chairman of the Rivers APC structure that ran every single primary between December 2024 and May 2026. The primaries that cleared Kingsley Chinda as the governorship candidate, the primaries that cleared all 29 Wike Loyal Assembly incumbents, the primaries that blocked all 32 Fubara-aligned aspirants, all of them, conducted under a leadership that a court has now said was never legally constituted. And that is only trap number one. There are two more. Each one sits at a different level of the judicial system. Each one targets a different pillar of Wike's 2027 architecture, and collectively, they create a scenario that nobody in Wike's camp saw coming. The most powerful political operator in the South-South, having spent 3 years constructing the most elaborate political machine in Rivers State history, may arrive at the 2027 ballot box to find that his candidates cannot legally stand on the platform he built for them. So the question is not whether Wike won the primaries. He did. The question is whether the primaries will survive long enough to matter. Before we go further, if you're new here, Naija Brief exists for one reason: to give Nigerians the political analysis that mainstream media won't. Whether you're in Abuja, Lagos, Kano, Port Harcourt, or London, this channel is for you. Hit subscribe and stay with me. This gets deeper. Trap 1. The Okocha nullification, the foundation judgment. Let us start with the structural flaw of Wike's 2027 architecture, the Rivers APC chairmanship. Emeka Beke was elected Rivers APC chairman in 2021. He was subsequently suspended by the National APC Working Committee, which recognized Tony Okocha as a Wike ally, as the legitimate chairman. A Rivers State High Court reinstated Beke, but the National APC continued backing Okocha. That dispute ran as a parallel reality inside the Rivers APC for over a year. On May 29, 2026, 8 days after Chinda won the APC governorship primary under Okocha's structure, the Court of Appeal in Port Harcourt upheld the High Court's nullification of the congresses that produced Okocha and his executive. The ruling was delivered by Justice Elfrida Oluwayemisi Williams-Dawodu. The Beke-led faction's response was immediate and total. Its spokesman, Darlington Nwaju, issued a statement declaring that all actions taken by the Okocha faction between December 20, 2024 and May 29, 2026 were, and I quote, illegal, null and void. All nominations, all representations, all communications, all political decisions of no effect. That window, December 20, 2024 to May 29, 2026, covers every primary that produced every Wike-aligned candidate for governorship, National Assembly, and State Assembly in Rivers State. All of them. Conducted under a leadership that a court has now said was never legally constituted.
Trap 2. The Chinda defection, the candidate's constitutional wound. Now, let us examine the second trap, which operates independently of the first and targets the governorship candidate personally. Kingsley Chinda won the APC governorship primary on May 21, 2026. On that same date, he was still the officially recognized minority leader of the House of Representatives, a position he held on the PDP platform. The minority leader position is constitutionally tied to party membership. You hold it because your party is the minority. You lead the minority because you are a member of it. His formal defection to APC and resignation as minority leader were not announced at the House until June 2, 2026, 12 days after he won the APC primary. The Speaker of the House, Tajuddin Abbas, read Chinda's letter during plenary. The letter stated the resignation was effective from April 23, 2026, but investigations by Daily Trust found no public record of Chinda formally communicating his departure from PDP to the House before that plenary session. The Association of Legislative Drafting and Advocacy Practitioners had filed a suit at the Federal High Court in Abuja on May 12, 2026, 9 days before the primary. The suit invoked Section 68 1G of the 1999 Constitution and the Electoral Act 2026. The argument, Chinda's defection from PDP to APC did not comply with constitutional requirements governing legislative defection. His continued occupation of a PDP legislative seat while contesting under APC was, in the suit's language, unconstitutional, unlawful, and contrary to democratic ethics. The lawyers asked the court to bar Chinda from the 2027 election entirely, direct the Speaker to declare his seat vacant, and compel INEC to conduct a by-election in his constituency. Chinda's camp argued he had already resigned as of April 23rd. ALDRAP argued the Constitution does not permit a legislator to simply backdate their departure from a party without triggering the vacancy provisions. That is now a live dispute before the Federal High Court. Trap 3. The 27 lawmakers, the legislative cascade. ALDRAP has separately sued Chinda and 27 current Rivers State legislators, asking the court to determine whether their defections from PDP to APC complied with Section 68 1G and 109 1G of the Constitution. These are the provisions governing defection of legislators. If you defect without a constitutionally recognized merger or party split, you lose your seat. The PDP's internal leadership disputes had previously provided a shield. Legislators could argue their party had fractured, meeting the constitutional exception. But ALDRAP's specific counter-argument is, by April 2026, the PDP had resolved its internal disputes, conducted primaries, and functioned as a stable party. The constitutional exception no longer applies. Every defecting legislator therefore faces potential seat loss. If the courts agree, the consequences cascade. Pro-Wike lawmakers who defected to APC and were cleared for assembly primaries could lose both their current assembly seats and their right to contest the 2027 election on the APC platform simultaneously. Wike's response to all of this has been striking in its calm. He told journalists, "Wait until INEC publishes the list of candidates in July." He said Beke does not understand the issues. He said there is no threat to the APC exco. What does it mean when a man who has deployed every available judicial and political tool against Fubara for 3 years responds to 3 active court threats against his own structure with this level of apparent equanimity? Is he genuinely unconcerned, or is he managing the optics of a problem he knows is serious? Hold this question.
The constitutional architecture of the 3 traps. Let me explain why these 3 cases are more dangerous together than any one of them is separately. Trap 1. The Okocha chairmanship nullification attacks the structural legitimacy of the primaries themselves. Under the Electoral Act, INEC is required to recognize candidates submitted by the legitimate leadership of a party. If the Okocha executive that conducted and certified the primaries was not the legitimate APC leadership in Rivers State, then the question of whether INEC can or should recognize the candidates produced by those primaries becomes judicially live. The APC National Working Committee still backs Okocha, but it is backing a structure that 2 courts, High Court and of Court of Appeal, have now said was never legitimately constituted. Trap 2. The Chinda defection suit attacks the candidate's eligibility at the constitutional level, not the party structural level. Even if Trap 1 is resolved in Wike's favor, even if Okocha's primaries are validated, even if INEC accepts all the candidate submissions, a federal high court ruling that Chinda's defection was constitutionally defective would disqualify him from the ballot independently. These are parallel tracks. Winning one does not necessarily save the other. Trap 3. The 27 lawmakers defection suit attacks the legislative architecture that Wike has spent 3 years constructing. The pro-Wike assembly majority was the instrument of every impeachment attempt against Fubara. It was the structure the Supreme Court validated in February 2025.
If those lawmakers lose their seats due to constitutionally defective defections, the entire legislative bloc that formed the backbone of Wike's Rivers state power disappears before the 2027 election cycle. The INEC deadline dimension. Here is the clock that makes all three traps time-sensitive. INEC is scheduled to publish its final list of candidates for the 2027 elections in July 2026. Once that list is published and certified, the window for pre-election injunctions narrows dramatically. After candidate certification, challenges must go through election petition tribunals, which operate under different procedural rules and time limitations. The ALDRAP suits and the defections legal challenge are operating in a specific window between now and INEC's July publication. If any of the suits produces an injunction or a disqualification order before that deadline, it directly affects who appears on the ballot. After that deadline, the legal landscape changes. This is why Wike's weight of the INEC list response is calibrated, not dismissive. He is pointing to July as the moment when the judicial picture will either clarify in his favor or force his camp to activate alternative platforms through the Rainbow Coalition. The APC National Working Committee's impossible position. The APC National Working Committee is now caught in a structural contradiction it did not anticipate. It recognized Okocha, it backed Okocha's primaries, it received and validated the candidate submissions from Okocha's structure. It cannot now simply undo those submissions without triggering a fresh internal crisis. But if it refuses to reconcile the Beke executive with the Okocha-conducted primaries, it is asking INEC to certify candidates from a primary process that two courts have described as legally void. That is an INEC liability, not just a party problem. And INEC has its own institutional incentive to avoid certifying candidates whose eligibility is under active judicial challenge at the appellate level. Wike used the court system as his primary weapon against Fubara for 3 years. The Supreme Court ruling of February 2025 that validated Amawe Fole's assembly was Wike's most decisive institutional victory. The irony of the current situation is precise. The same judicial apparatus that Wike deployed to paralyze Fubara's government is the same apparatus through which Fubara's allies and independent legal actors are attacking Wike's 2027 structure. The weapon has not changed. The direction of fire has.
What Wike actually has: the Rainbow Coalition insurance. Before we overstate the threat to Wike, let us be analytically fair about what his position actually is. Wike has always understood that the APC platform was not his only vehicle. The Rainbow Coalition, spanning APC, PDP, Labour Party and Action Alliance, was explicitly designed as a multi-platform insurance structure. At the Rainbow Coalition luncheon in Port Harcourt, Wike said the coalition would collectively select the governorship candidate. He explicitly refused to formally endorse Chinda as the APC flag-bearer. He said no final decision had been taken on the governorship ticket. That positioning, which many observers interpreted as political maneuvering at the time, now reads as structural foresight. If the Okocha primaries are voided and Chinda's APC candidacy is challenged, the Rainbow Coalition can designate its preferred candidate, potentially George Kelly on PDP, or even a different APC figure if a fresh primary can be conducted under Beke's structure. He backed an outcome, not a candidate, and the outcome, a Wike-aligned governor in Rivers State from 2027, does not require any specific candidate to survive the legal gauntlet. What the legal traps actually target: the timing game. The ALDRA suits and the Beke factions challenge are not trying to remove Wike from politics. They are trying to do something more specific and more achievable: delay, create uncertainty, force INEC to hesitate, generate enough judicial noise around the candidate submissions that the July certification window becomes complicated. In Nigerian political litigation, the objective is rarely to win outright. It is to create a condition of uncertainty that forces the other side to make concessions, redirect resources, or accept a negotiated settlement. The Chinda defection suit, even if it ultimately fails, forces Chinda's legal team to spend time and money defending his eligibility instead of building his campaign for governorship. The defection challenge, even if the APC NWC overrides it, creates a public narrative that the Rivers APC primaries are legally contested. That narrative affects candidate credibility, donor confidence, and voter perception. This is the Wike playbook, now being used against Wike. Fubara's role, the governor who is still governing. Fubara has not publicly commented on any of the three legal traps. He does not need to. He is still governor of Rivers State until May 29, 2027. The ALDRA suit was filed by a lawyers' association that includes members from Chinda's own constituency, Obio Akpo. The defections challenge is being driven by the Amaechi-aligned APC bloc. These are not Fubara's organizations. He is not on the court documents. His fingerprints are not visible. But a sitting governor with 12 months of executive authority, a state patronage apparatus, and a motivated political base has multiple ways of supporting legal challenges without appearing in them. Litigation is expensive. Lawyers require sustained briefing. Evidence gathering requires institutional cooperation. A governor who wants a legal challenge to be well-resourced and well-argued has tools available that do not require him to file a single court document. Whether Fubara is exercising those tools is not verifiable from public sources. What is verifiable is that the legal challenges are active, well-structured, and are attacking the precise architectural weaknesses in Wike's structure that Fubara's political allies have been identifying since May 2026. George Kelly's eligibility is also being challenged in the same ALDRA suit. George Kelly is the PDP governorship aspirant in Wike's Rainbow Coalition. He is a Wike ally who was appointed as Director General of the Border Communities Development Agency by President Tinubu. The suit argues he did not resign from that government appointment within the required period before seeking elective office. If both Chinda and George Kelly face eligibility challenges simultaneously, the Rainbow Coalition's candidate pool narrows significantly before any ballot is cast.
The Amaechi factor, the silent beneficiary. There is a fourth actor whose silence throughout this entire legal episode is conspicuous. Rotimi Amaechi, former transportation minister and 2 times Rivers governor. The Beke faction is backed by the Amaechi bloc. Emeka Beke was elected chairman in 2021 during the Buhari-Amaechi era of APC dominance in Rivers. His reinstatement by the courts removes the Okocha-Wike structure and potentially restores APC authority in Rivers to a chairman who owes nothing to Wike. If the Beke structure is validated and the Okocha primaries are voided, a new primary must be conducted. Under whose supervision? Beke's. Who benefits from a fresh Rivers APC primary conducted by an Amaechi-aligned chairman? Potentially Tony Okocha, who has contested and lost twice as an Amaechi candidate and who explicitly said he would not step down for anyone in the 2027 race before being pressured out. The legal challenge that looks like a Fubara move may be simultaneously an Amaechi repositioning, or it may be both at once. In Rivers State politics, those possibilities are not mutually exclusive. Wike's calm response to the 3 legal traps in Rivers is not genuine unconcern. It is a calibrated public posture designed to prevent the traps from becoming a rallying narrative for the opposition while his legal team works the INEC deadline. His "wait for July" instruction to commentators is the language of a man who believes he has enough judicial and political resources to navigate the next 6 weeks. Whether he is correct will be answered in the INEC publication. But the calm itself is information. It tells you Wike has a plan. It does not tell you the plan will work. Now, if what I just told you surprises you, drop a comment below. I want to know your reaction before we get to the part that changes everything. what this story tells us about Nigerian electoral law. The three legal traps in Rivers are not an anomaly. They are a symptom of a structural problem in Nigeria's electoral architecture, the gap between party internal processes and judicial enforceability. Nigeria's Electoral Act and Party Constitution framework assume that party chairmanship elections, congresses, and primaries are conducted under legitimate leadership. When chairmanship itself is contested, when two executives claim authority simultaneously, each with court orders in their favor at different judicial levels, the entire downstream process becomes legally fragile. Every nomination, every clearance, every candidate submission from that disputed structure inherits the contestability of the chairmanship dispute. This is not a new problem. It happened in PDP factional dispute under Jonathan. It happened in APC under Buhari. It is happening now in Rivers. But it is happening now at a scale and with a level of public visibility that creates a genuine opportunity for legislative reform if the National Assembly chose to act. A mandatory INEC verification of chairmanship legitimacy before party primaries, for instance, would prevent this entire category of post-primary litigation. That reform has been proposed by civil society organizations multiple times. It has never been passed.
The cost to ordinary Rivers people. For the ordinary Rivers State resident, the trader in Eleme, the student in Rumola, the farmer in Eche, 3 years of political crisis followed by a 2027 electoral season consumed by candidate eligibility litigation means one thing: governance is a secondary activity. Infrastructure decisions are deferred, contractor payments are delayed, local government service delivery operates at minimum capacity because every political actor in the state is focused on the 2027 outcome rather than the 2026 budget delivery. Rivers State is the second largest contributor to Nigeria's federation account. The cost of its governance paralysis is not borne by Wike or Fubara or the lawyers in Abuja Federal High Court. It is borne by the people who live there. Diaspora and international dimension. For Nigerians in the United Kingdom, the United States, and Canada with roots in Rivers State, the combination of primary legitimacy disputes, candidate eligibility litigation, and the INEC certification deadline creates a 2027 electoral environment in Rivers that is genuinely unpredictable. Investment decisions, property transactions, and remittance allocation into Rivers State are all affected by governance continuity risk. A governorship race that may produce multiple parallel candidacies, contested INEC certifications, and post-election tribunal processes is a risk environment that discourages private investment in an already challenged state economy. International observers and the U.S. State Department have previously flagged Nigerian intra-party processes as areas of concern for democratic credibility, a situation in which the APC's own governorship candidate in a major state is facing disqualification suits at the Federal High Court before INEC has even published its candidate list will attract international monitoring attention that the Tinubu administration does not need in the run-up to a presidential re-election year. The strongest argument for Wike's position. The most credible version of Wike's defense is this: Nigerian courts have produced conflicting orders at different levels in political party disputes for decades. The APC National Working Committee, the supreme governing body of the party, recognizes the Okocha executive. National party leadership takes precedence over state judicial rulings in internal party affairs. The appeals court ruling was on an interlocutory matter that has been sent back to the trial court for full hearing. It is not a final judgment on the merits of the chairmanship dispute. The Beke faction's characterization of the ruling as voiding all Okocha-era decisions is legally aggressive advocacy, not settled law. INEC will apply its own legal analysis to candidate submissions, and INEC has consistently deferred to national party leadership on internal disputes. On Chinda, he resigned from PDP effective April 23rd, 2 months before the primary. Whatever procedural gaps existed in communicating that resignation to the House were administrative failures, not constitutional defects sufficient to void a governorship candidacy. The courts have upheld candidate eligibility in situations with far messier defection timelines than this.
And on the 27 lawmakers, the PDP's internal stability at the time of their defections remains legally contested. The ALDRP affidavits claim that PDP had resolved its crisis by April 2026 is a factual assertion, not a judicial finding. That assertion must be tested at trial. Until it is, the constitutional exception potentially remains available to the defecting lawmakers.
Where the argument faces difficulty. First, two courts have now agreed on the Okocha nullification. The High Court and the Court of Appeal are not the same judicial level. When an appellate court affirms a trial court's finding, the precedential weight of that finding increases materially. Wike's lawyers may be correct that the matter has been remanded for full trial, but a remand after appellate affirmation of the core finding is not the same as a complete overturning. The legal risk to the Okocha-era decisions remains real. Second, Chinda's formal defection announcement was made by the Speaker on June 2nd, 12 days after the primary. Whatever the letter's stated effective date, the absence of any public record of PDP departure before the primary creates an evidential problem that Chinda's lawyers must address. The court will examine the Hansard. If the record shows Chinda participating in PDP minority caucus activities between April 23rd and May 21st, the backdated resignation letter becomes very difficult to defend. Third, on the 27 lawmakers, the PDP indeed conducted successful primaries in Rivers State. That is a matter of public record. The ALDRAP's affidavit's factual claim about PDP stability is therefore not frivolous. A trial court will have to make a finding on it, and that finding could go either way. Misconception. These are nuisance suits that will be thrown out before July. ALDRAP's track record includes cases that produced significant judicial outcomes. The suits are professionally filed, constitutionally grounded, and supported by detailed affidavits. They will not be resolved in 6 weeks. The uncertainty they create is the point. What to watch before the INC July deadline. First signal. Watch whether any of the 3 suits produces an injunction before July. An injunction restraining INC from certifying specific candidates, even on an interim basis, would be the single most consequential judicial outcome before the deadline. It would force INC into a legal consultation process that delays the certification and potentially opens a window for candidate substitution. Second signal. Watch the APC National Working Committee's response to the Beke faction's formal declaration that all Okocha-era decisions are void. The NWC must now either publicly reaffirm its backing of those decisions, knowing they are judicially contested, or open a reconciliation process with the Beke structure, which would effectively require new primaries. Either path creates political costs. Third signal. Watch Chinda's Hansard documentation reveal any PDP participation between April 23rd and May 21st. That is the specific factual question on which his eligibility case may turn. If his lawyers can produce clean Hansard evidence of no PDP participation after April 23rd, his position strengthens significantly. If they cannot, the case becomes materially harder. Fourth signal. Watch Amechi. If the Beke structure is validated and fresh primaries become possible in Rivers APC, Amechi's response will tell you whether this legal campaign was always a part of a broader repositioning strategy or whether it is genuinely about constitutional compliance.
The close. Return to the hook. We started with a judgment, a court ruling that said the structure Wike built was never legitimately constituted, and we asked, does the most powerful political operator in the South-South arrive at the 2027 ballot box to find that his candidates cannot legally stand? Here is the measured answer. Wike is not finished. He has the Rainbow Coalition. He has the APC-NWC's backing. He has multiple candidate pathways. He has a track record of navigating judicial challenges that would have destroyed less experienced political operators. But he is facing something he has not faced before: the systematic application of the same legal strategy that he perfected against Fubara, now turned against his own structure on 3 simultaneous fronts by actors who understand every gap in the architecture because they watched him build it. the Okocha chairmanship case, the Chinda defection case, the 27 lawmakers defection case, 3 courts, 3 constitutional hooks, 3 INEC deadline pressures, each one manageable separately. Together, they create a compound uncertainty that no amount of political confidence can wish away. The hidden legal trap is not one trap, it is 3 interlocking ones, designed to operate on parallel tracks so that defeating any single one does not neutralize the others. This architecture mirrors precisely the strategy Wike used against Fubara: simultaneous pressure from the judiciary, the legislature, and the party structure, keeping the target perpetually occupied with defending existing positions rather than advancing new ones. The playbook has not changed. The author has. Here is the reform argument that every Nigerian voter should draw from this story. 3 years of political crisis in Rivers State, including a 6-month state of emergency, 3 impeachment attempts, and the systematic exclusion of an elected governor's allies from party primaries, have all flowed from one structural gap. Nigeria has no mechanism that legally prevents the weaponization of party internal processes for political management. The Electoral Act 2026 was supposed to address some of this. It has not. The legal traps now closing around Wike's 2027 structure are at root the same traps he used. They work because the law allows them to work. That is the reform demand. Close the architecture, not just the individual cases. What ordinary Nigerians can do is specific and actionable. Demand that the National Assembly conducts a public hearing on the Electoral Act's provisions governing intra-party chairmanship disputes before INEC primary certification. Demand that INEC publishes its legal opinion on the Rivers APC chairmanship dispute before the July candidate list. And if you are in Rivers State, the 2027 election will be decided not in any courtroom but at your polling unit. Register, stay registered, make the decision at the ballot box rather than surrender it to the litigation process. If this analysis gave you clarity, share it with one person who needs to understand what is really happening in Nigeria. Like, subscribe, and I will see you in the next one.